Alrighty.
We have launched.
That is correct. Welcome, everybody. You're listening to Planet Green Trees, episode number 191. We're calling it Medical Marijuana Jury Trials. Our special guest tonight is rockstar Lord Neil Rockhind. We'll talk about that in 1 second. Today, of course, is March 20th, 2014. Calling number is 1-347-326-9626. I'm your host, Michael Komorn from Komorn Law, and with me in the studio to bring you the premier blog talk, informative, up-to-date, relevant medical marijuana and marijuana reform radio. Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
The one and only, recently arriving, Rick Thompson, the Compassion Chronicles editor-in-chief. Welcome, Rick.
Recently arriving, but on time.
Absolutely, right on time. And
as opposed to
unaccounted for and whereabouts unknown, Jamie Lowell, the producer of Planet Green Trees from Third Coast Compassion Center. I want to remind everyone, if you don't like something we're doing on the show or don't like any of our guests, call Jamie. He's the one that wants to hear about it.
I called him several times today.
Tonight, we're going to be talking about a medical marijuana dispensary criminal case has been dismissed without any recharging or an appeal reversing the dismissal decision. The medical marijuana community also is worried that lawmakers in Washington state will fail to pass regulating legislation this year, leaving the patients vulnerable. PTSD was officially added to the list of qualifying conditions in Michigan. And our favorite topic, the hotel certification card mills for medical marijuana certifications continue to be debated, and we're going to hear about that a little bit tonight. I know someone's chomping at the bit. Oh, what do you know? He just came in here. Jamie the Lowell. Welcome, Jamie. Hello.
Hello.
Joining us tonight, as I said, the one and only superstar attorney Neil Rockhind of Rockhind PC. He's going to be offering his perspective on some issues concerning the hotel recommendations for medical marijuana, the doctor-patient relationship. He's going to talk a little about the dispensary case he was involved in, and we're going to coalesce about a trial that we've each had in similar circumstances, similar judge, same prosecutor, and I'm going to rant about that in a little while, but I'm going to try to lay some of the foundation for some of the discussion, at least of the challenges and some of the things that occurred during a medical marijuana trial. Carrie Boyder, good friend of the show and legislative analysis and nationally recognized medical marijuana activist from the state of Washington, is going to update us on the fate of the medical marijuana program in the aftermath of the legalization being approved by voters in 2012. Joining us to continue our discussion on the issue from last week, does cannabis cure cancer? We're going to be here from Peter O'Toole, Uncle Pete as he's known to many, a cannabis farmer and oil maker from Prudentville, Michigan. Peter is also the co-founder of Cannabis Camp. Pete became aware and involved with cannabis as patients in need of alternative treatment, has gone on to teach and help many others in need. We're going to hear from him. I'm going to rant in a little while, but I do want to give a couple shout-outs to our friends, supporters. First, Dewey and Pam. Looking forward to catching up with you guys. I know Dewey's been on the vacay, and hope he's all ready to be on time and get us where we got to be. And Pam, of course, thanks for making all that happen. I want to thank the Michigan Medical Marijuana Association, michiganmedicalmarijuana.org. Thank you to all the moderators and administrators volunteering to participate in a venue and forum that involves a conversation about medical cannabis. Komorn Law, 1-800-656-3557. Marijuana Ranch, 313-422-5281. Call for a cultural tour of the hemp factory. Good friend Dr. Kumar Singh of Green Light Clinic, 248-390-0574. Not too long ago, I think it was in the episodes 180 to 183, we were addressing, actually 185, no, maybe not, 183. But anyways, the issue of hotel certifications, and we had a panel on. Dr. Singh was there, of course, as well as Dr. Crocker and some other guests, and we addressed this issue, but I will say that as you listen to this show tonight, keep in mind that when you go to a doctor, you're going there to have someone that's going to defend the certification. And as a doctor is looking at you as a patient, they're determining whether or not, should be determining whether they're willing to come to court if necessary, and whether their decision to recommend marijuana is something that they're willing to justify. And I know that the doctors working in this area are very challenged by a lot of different factors now, and I know Dr. Singh, amongst other doctors we talk about, have been working diligently to try to conform to the seemingly insane requirements that have been set out. Barbara and Tori Clark, we wish you our best. I know Tori's not doing well in hospice, and all the torture you guys had to go through. Give a big shout out to our friend Eric Gunnels, the trustee for Tedford Township. Text him at no, I'm just kidding. I think that's all the shout outs for it now. All right, I'm going to rant here for a second, and a lot of things to talk about. You know, I wanted to talk a little bit about the PTSD. This is such an important fact. I wrote a little blog about it, how it's nice to see, actually, when you put aside what is oftentimes the public safety issues as the marijuana issue has been framed, medical marijuana, by the law enforcement community. When you put that aside and you're really looking to it for its medical uses, it's nice to see when the process can work and that terrible Michigan Medical Marijuana Act all of a sudden can work. And there's a lot of people involved that made that happen, and too many to mention right now, but it didn't go without some fight. I know Matt Abel, I know I'm going to mention a couple of people. Matt Abel, I know, filed the initial case to stir up what needed to be stirred up to get the Lara operating, and that eventually convened a panel, and several years later now we finally have PTSD is passing. But, and of course, there's all the patients, and John Evans, who I think is going to be on the show, if not tonight, next week, pivotal and all that. It's too many to mention, but I just know there's some significant players that really were able to frame the issue in a medical way. But that's not for the rant, and that's just a partial intro. Jamie, how much time do we have? Just kidding. I'm going to rant a little bit. You know, first of all, let me start by saying no one should be arrested for marijuana. It really is ridiculous. It's just a plant, for the love of God. For some reason, in my practice after 21 years, I find myself defending medical marijuana patients, recreational or personal use individuals, caregivers, and it's ridiculous already. But it's still a thing going on. I think there's a lot of disparity at times in terms of the progressive movement in Michigan relative to medical marijuana and marijuana reform, and the way that some of the institutions that are enforcing these laws, I think there's sometimes a gap there in the understanding. And again, it depends what venue you are in and what may be justifiable in some instances, and some of the police don't see as a problem, may be a huge problem elsewhere. But we're going to talk about jury trials later on with Neil. I think he's calling at 8:30. And the backdrop of all of this is that I've had a couple of medical marijuana trials. Neil's going to talk about his, and there's some experiences that came about that are interesting that people should understand. And part of the analysis, of course, is that for starters, unlike other types of criminal trials, you're more likely to find individuals that are going to be in favor of what can only be described as a trending topic. I mean, everybody knows, has heard in Colorado, this is a paradigm shift, and people that are paying attention are going to be aware of that. So unlike other types of crimes that have been charged, when you get before the pool of possible jurors who have been summoned from the clerk of the court to appear for their obligational jury duty, it's more likely that from that pool you're going to be choosing from individuals that are aware of the changes and most likely voted for the law, and that if it's a fair pool and it's done correctly, you've got not less than a majority in every single county. And of course, that is something to consider. I mean, there's an argument that can be made that if every single marijuana case went to trial, they would have to end prohibition because the system would fall apart because there's so many cases. But that may not be, right for every single case, and lawyers advise not in advocacy, unfortunately, despite whatever desires, but they have an obligation to their client for whatever best is for him or her. And but there's always a different approach, I think, when you're talking about medical marijuana and some of these marijuana cases, that it is a different venue. There's a lot of different factors about medical marijuana, medical marijuana or marijuana, just because of the environment of the time that we're living in. And it's interesting because whomever that jury is, you're really going to get where the rubber meets the road, so to speak, of if they voted for it and if they, believe in it, whatever the facts are that are presented, at the end of the day, arguably independent of whatever the jury instructions are, they're either going to draw a conclusion, yes, this is medical, or no, it is not. And I've advocated that a lot, but I've also seen how the beauty of the Michigan Medical Marijuana Act and everything it was intended for has been twisted and turned and utilized in such a way that it has become, instead of the protection, the shield, the prophylactic that it was intended, it's become a sword of how you're finding ways to make people seem like they're violating, so they're not doing something right. And, the only way to really explain it, I don't even like saying this, but the way the law has been analyzed by the Supreme Court, it still remains under any kind of strict scrutiny or intense scrutiny, a lot of ambiguities. They still exist. I don't like saying it. I mean, it was clear when it started, but now that some stuff has been laid down and there's been the law of the land and some of these things, there still remains issues that, and I say ambiguous in that they're not to normal thinking people, but to a debate between a law enforcement, a narcotics enforcement officer, that results in you being outside of Section 4 and having to defend yourself under Section 8. And this is the unfortunate environment that we're living in oftentimes, and that's why most lawyers with common sense in this area are going to explain and advise you to do all you can to remain in strict compliance with Section 4, but be prepared for in the event that something happens where you're outside of it or you're in a strict evaluation by the law enforcement. They want to say because there's a key ring that leads to the basement that's hanging near the basement that someone in the family could have gotten the key and gotten into the grow room, and therefore now you have a felony charge. I mean, but I digress a little because that's the circumstance. I just want to talk. I got a little bit of time. I had a trial out in Oakland County. I've had a couple of them, and Neil's going to talk about his. And there's a lot of things that were similar, but I think there's some overriding themes I just wanted to kind of talk about that were interesting. Of course, both cases resulted in at least establishing that a question of fact existed that needed to be resolved by the jury. My case was kind of interesting. It involved a very sick person who had been in bad shape. It had been, been on disability. He's a high school athlete. By the time he was 31, he'd gained like 100 pounds and just basically sitting on the couch taking opiates. And after he got certified, sometime like February 2011, I think it was, for the next year he started using medical cannabis. He wasn't even a recreational user, and he literally started going back to the gym and working out, and started working, whatever the allotted amount is when you're on disability in a temporary situation. And then he got raided in November, December of that year, 2012. And the circumstances were that he as a patient was not growing, even though his card had, he was able to possess the 12 plants, but he met an individual who he was led to believe was a caregiver. Now, this doesn't sound like a good story, I know, but not everyone is thinking in terms of that like they should be, and this is a period of time when better judgment, well, in other words, he shouldn't have needed to call a lawyer, but we got involved, and this is what happened. The patient, who was a sick person, was acquiring cannabis from someone that they were not registered to. However, in Michigan right now, they're allowed to get it from anybody, and they're immune from any kind of prosecution. In this particular situation, this individual had dropped off wet marijuana, and that was the program. 4 ounces, wet, beginning of the month, would dry, he was charged less, and it was a regular program. The person who was acting as his caregiver, not connected, but who cares, had dropped some cannabis off, and then left the place, was pulled over, and had jars in his car and other paraphernalia. And the police, stressed him, as they would say, and before you knew it, he was working with them to somehow set up a buy of some kind with my client, who maintained throughout the entire case that this individual was his caregiver, acting as his caregiver. So this individual, we'll call the snitch, but he was known to everybody, and I made sure that he calls my client and says, I need to come by. Actually, this is what happened. Before we even got to there had been a drop-off of the normal monthly supply. A couple weeks later, he calls and says, "Listen, I need to get some of that back, but my plants are dry and I'll be able to bring it back in about a week. So I need like a quarter ounce." So the caregiver comes back. This transfer is made. There's people sitting in the room that observe the whole thing take place. The guy leaves and he gets pulled over. And what is weird is that he has these jars, as I explained, and some other paraphernalia, but the marijuana they just picked up is not there. It honestly was dropped on the path from my client's apartment to his car. So with this being said, I don't know, maybe they planted it there, they may have planted it there, but either way, this event had just taken place unequivocally, and they call my client and say, "I got to come back and pick that up." So my guy goes out, finds it where it is, brings it back in. The guy shows up, he leaves, and of course, he's patted down before, no money's exchanged, and he returns with, quarter ounce of marijuana. They then get a warrant, they come in, and he has a little more than 4.5 ounces, maybe. Some of it's wet, it's in different jars. And he gets charged with the delivery of marijuana for the exchange to the snitch and the possession with intent to deliver marijuana from the marijuana that was being possessed at his home in his closet, wet and packaged and put away, drying in jars. So it's a challenging case, nonetheless. And if I didn't mention this, when he was arrested and they came and took him, he made a confession to the police that is videotaped. And at the district court level, I convinced the judge to throw out the confession, but that doesn't matter because in circuit court they can re-roll, and that's what happened to my client and my detriment. But nevertheless, we went for it. It wasn't that bad. He explained some stuff. He's a scared individual, and a lot of people put in those pressure situations, will say anything, until you've been there and you know it, but people understand that. And so the story goes that we made it out of the Section 8. A lot of arguing between myself and the prosecutor. It was a very contentious debate. The judge had ruled on the jury instructions using the, post-culpable date bona fide relationship and was applying it retroactively. And I filed a bunch of, the jury instructions are an important part of every single trial. And there's a lot of ways that can be sliced. And how it is sliced is lacking in any medical marijuana precedent. I would argue that there's plenty of precedent to support my legal theories as to why it should be the way that I say it is, but there are no medical marijuana jury instructions. There's even more other issues regarding this with existing jury instructions that can actually be utilized very effectively for people charged with marijuana crimes. But nonetheless, the important factor of the trial, which I'm going to tell you about the result, but there's a point, I know Neil's going to talk about this a little bit as well. I think it really goes to the heart of the matter. If I could step back and kind of entwine the problems with what I see with the Michigan Medical Marijuana Act and this event that took place in court, was that my client was going to testify clearly that the marijuana that was being possessed when they raided was for his medical use. And he had done that at the Section 8 hearing. And he said he used 4 ounces a month. And he explained how he used it, explained this unbelievable story, actually, from beginning to end over a period of time of how, in fact, he utilized cannabis medically and really changed his entire life around in a lot of different ways. And the prosecutor, same prosecutor in Neil's case, he can talk about that, but filed a motion giving us notice of their intent to call an expert on what is medical, what is an amount reasonably necessary, essentially, to challenge that, knowing that that's an issue for the affirmative defense at trial. And there was different strategies. I was, and me and Neil conferred a lot on this, but the point, and when Neil comes on, I'll let him explain the beauty of the way it was done, but the point of it is that there is no expert on the other side about medical marijuana, other than the drug enforcement officer who they are going to call, who will say unequivocally and based on nothing other than training relative to drug enforcement and never spending a moment of their life with a medical marijuana patient, as to what is a reasonable amount or what is medical or what is consistent with drug trafficking. And I made a big hoop-de-doo of this, I would say, and I And even after we put our case on where my client testified and his mother testified and the other witnesses testified, they put the same witnesses up, the same two witnesses, to rebut our story again with their special specialist in drug trafficking and calling it. And I got to tell you, I think at the end of the day, this was the worst thing that they could have done, in my case, I would say, because the shallowness by which those principles were offered, it was couldn't be described as anything other than that. And during my closing, I will tell you, I did not hold back at all of the insult that they can put a drug enforcement officer on the witness stand and try to pull the wool over the jury's eyes and make them believe that he knows anything about medical marijuana, that he can even begin to contemplate it. And there's no one in line to do a better job anywhere. There's no consciousness of thinking about it other than through the eyes of drug enforcement, which is the problem by which much has gone on with the Michigan medical marijuana. It brings us back to the core problem, which is that it cannot and should not be viewed in the eyes and through the eyes of a public safety mentality. The beauty, if there was one at all, of the PTSD was that when you put aside the law enforcement, public safety issues, and you address it from a medical cannabis and what works for the patients, if testimony can reflect on it, things can get done. There's an understanding, there's application, there's assurances. But as we know, there's been virtually no training whatsoever in any way to help implement this act with an understanding of law enforcement. And I do understand that their process in this, their role in this, is to see things black and white. You're either in violation or you're not. But can this really be done when a law enforcement, the community, the ones that are most likely driving charges, driving investigations, are incentivized, have incentives to forfeit property, that if they can find you outside of Section 4, you then are subject to them taking your property. You got to post a bond. You got to fight to try to get some of it back. So these are two very important things that stand out. I think they're relevant in most instances for every trial. I think that, these law enforcement agents, I don't think it becomes irrelevant whether or not how they're being funded. Of course, the prosecutors would argue. But when that professional witness gets on the stand and says, "Oh, this is drug trafficking," how do you get paid? You don't have any incentive to say that. You have any incentive to declare that these are crimes, as opposed to actually looking at one study that may give some indications. I mean, I can't help but to give it away. But when you ask an officer if they're aware of the federal program that exists in terms of what a reasonable amount is, and my client allegedly had 4.5 ounces. The federal program is producing 8 to 10 ounces a month. So how can they say that, trafficking starts at? It's just a very, very silly way in which we are addressing this, I guess. And when I started out with nobody should be arrested for planning, I really mean that it is insane, and it all still revolves around a lack of education, a seemingly fear of something other than being outside of violence. What is bad that's happening? Tell me. I mean, even if that was, if you've got an opportunity to say, well, that may be wet marijuana, and I know the law says usable, unusable, and clearly those 12 plants that are hanging there and drying, they're soaking wet. They weigh a lot right now, but I get it. You got 12 plants. You're beginning to grow. You're not. What is in what would be so wrong of seeing it that way? What would be so wrong of understanding it in a workable manner? Why does somebody have to become a actual miracle worker with their timing and cycles of the plant growth? And why are we even talking about this, right? In any event, I think, though, retrospectively, and I hope Neil will agree, that fighting these cases is critical, and it's an opportunity in a lot of ways, and it's terrible that anyone should have to go through it, but every single trial is really an opportunity. It's an opportunity to push the ball forward. If you get good verdicts, you change the way the prosecutor is going to think the next time they're going to charge. My case ended up with the defendant being found guilty of the delivery to the snitch and not guilty of the possession with intent to deliver. And I concluded that it's very difficult to get past that delivery back under the theory that he's going to get it back a little while. Difficult because in a literal way, sometimes the jurors, see it as a delivery. We weren't denying it. We had explained it that it was given. How's he going to? If he cuts off his caregiver, it's not going to be a continuous supply for him. But I found it fascinating that they 100% found my client not guilty of count 2, which was the possession with intent to deliver, which was them looking at the prosecutor table and saying, that crap that you pulled by putting that detective on the stand and saying that was marijuana that was for trafficking and not for use, they said not guilty. That means that they didn't believe that crap. And that's a flaw in their case. It will always be a flaw in their case. And until they get on board, I think it can be beaten over and over and over again. All right, that's the rant. I don't want to get too far.
Good stuff.